Hello, and welcome to the ninth chapter, Impossibility of Performance or Doctrine of Frustration from the book Law of Contract. After studying this chapter, you will be able to understand impossibility of performance or doctrine of frustration. Impossibility of performance or doctrine of frustration. An agreement to do an act impossible in itself is void. A contract to do an act which, after the contract is made, because impossible or unlawful by reason of some event which the promiser could not prevent, becomes void when the act becomes impossible or unlawful. For example, where A agrees to pay B rupees 5,000 if he should swim from Bombay in Indian Ocean to Aden in 7 days' time. This is an agreement where both the parties know that it is impossible to swim and hence the contract is void. The doctrine of frustration is present in India under Section 56 of the Indian Contract Act 1852. It says that any act which has to be performed after the contract is made becomes unlawful or impossible to perform, and which the promiser could not prevent, then such an act which becomes impossible or unlawful will become void. It lays down a rule of positive law and does not leave the matter to be determined according to the intention of the parties. In Satyabrata versus Mugniram, the Supreme Court has observed that various theories have been propounded regarding the juridical basis of the doctrine of frustration. Yet, the essential idea upon which the doctrine is based is that of the impossibility of performance of the contract. In fact, the impossibility of performance and frustration are often interchangeable expression. Also, the meaning of the term impossible was explained under Section 56. The Supreme Court made it clear that unlike English law, the word impossible has not been used in the sense of physical or literal impossibility. The performance of an act may be impracticable and useless from the point of view of the object, and whether it forms the basis of the contract rightfully has to be decided by the courts. Also, in Sushila Devi versus Hari Singh, it was observed that the impossibility contemplated by Section 56 of the Contract Act is not confined to something which is not humanly possible, as it was a case of lease of property, which after the unfortunate partition, the property in dispute, which was situated in Gujranwala, went on to the side of Pakistan, hence making the terms of the agreement impossible.